Good afternoon, everyone. This is Laura Fudala again from the National Center for Healthy Housing. I think we're going to go ahead and get started. As we mentioned, we have quite a packed house of content here for you today. So I'm going to turn it over here to Amanda Reddy to kick us off and get us started.
Good afternoon, everyone. Welcome to the Legal Strategies and Mechanisms to Reduce Lead Poisoning webinar presented by the Lead Legal Strategies Partnership. As Laura mentioned, my name is Amanda Reddy, and I'm the Executive Director of the National Center for Healthy Housing. Laura also indicated, and I have to agree, that we do have an exciting but very packed webinar planned for you today, and we're going to get underway in just a minute. But first, we wanted to go over a few housekeeping items. Since we have so much ground to cover, all of the participants are going to be, and their phone lines are going to be muted throughout the webinar. The webinar is being recorded so that you can access this information again afterwards. There's going to be a lot of information thrown at you, so you can go back and review it later or share it with any colleagues that weren't able to join us today. Similarly, I'm sure that you may have questions or thoughts occur to you throughout the webinar. We're going to ask that you please either use the chat or question and answer function on your screen to share those questions and thoughts with us. If there's time during the webinar, we'll begin to address some of them during today's webinar, but otherwise we're going to use the comments and questions that you submit during the webinar and then in the evaluation afterward to plan follow-up communications and coaching both with individual communities and with the entire cohorts here. The evaluation will appear at the end of the presentation, and you'll be given some instructions about that, but it will also be emailed to you. And we really encourage you to be as candid as possible about your questions and needs so that we can really tailor future content accordingly and make sure we're getting you the information that is most meaningful to you. Finally, as a last point of housekeeping, the PowerPoint slides are attached as a handout here. So on the right-hand side of your screen, you'll see a little section that says handouts, and there's a PDF document there that you can download right now or at any point during the webinar to get access to those slides. With that, we'll go ahead and get started. I think many of you may be aware or remember through the application process that this initiative grew out of the work that had been done to shine a light on effective policies to prevent and respond to childhood lead exposures as cataloged in the 10 policies to prevent and respond to childhood lead exposures report, whose image is on your screen right now. This report recommended policies in 4 areas spanning priority and additional sources, where the work we're partnering with you and your communities is primarily focused, responses to children with lead exposure, and then data and research. We know that there are many pathways to eliminating lead exposure and different ways to achieve the policies recommended in the report, but many of them require or benefit from having a legal perspective. For instance, we know that many of you are looking to reduce exposure to lead paint sources in your communities by either developing or strengthening inspection and enforcement mechanisms at the local level. We also know that many communities have mounted successful legal strategies, including regulatory approaches and litigation against municipalities, the paint industry, negligent landlords, and regulators. And so to help spur action in other communities, including all of you joining us on this webinar today, the National Center for Healthy Housing, ChangeLab Solutions, and Earthjustice, with generous support from the New York Community Trust, formed the Lead Legal Strategies Partnership. And on that note, I'd like to turn it over to Arturo Garcia-Costas from the New York Community Trust, so he can say a few words about why the New York Community Trust has been supporting this work. Arturo?
Thanks, Amanda. So for those who are not familiar, the New York Community Trust is New York City's community foundation, and it's one of the oldest and largest in the country. But because of the nature of the foundation, we have a number of funds that focus outside of New York City, and indeed 80% of the grant making for which I'm responsible at the Trust focuses outside of New York City through our national and international environment program. One of the strategic priorities in that program is environmental health, and most of the grant making that we do through our environmental health program focuses on toxic chemicals, toxic chemical reform, reform of toxic chemical regulations such as TSCA, market-based approaches to reducing the use of toxic chemicals in consumer products, and lead. For the last 5 years, since 2014, when the board approved a new strategy for the program, we have done a number of grants focused on lead, both globally, nationally, and through this grant locally and locally in New York City. We have supported the global effort to phase out leaded paint, since lead paint is still sold in about 60 countries and manufactured in 40 others. We have also supported some statewide efforts in New York and efforts through the Clean Water Fund and through Earthjustice to address other sources of lead in our economy, included leaded aviation gas. One of the things that we have learned over the last 5 years in doing that grant making is that there are significant gaps, both financing gaps for remediating lead conditions in housing, particularly older housing pre-1972, or is it 78, pre-1978 housing buildings, and in terms of local at the city level, from a primary prevention perspective. Many of the, as I'm sure we'll hear this afternoon, as those on this call are aware, much of the state laws focus on secondary prevention, which means a child is tested for a certain level of lead, and then an intervention is called for of some sort. But by that point, sadly, damage has already been done to the child and other residents of that home. And the best idea is to prevent that exposure to begin with. So amongst the gaps that have been apparent over the last 10 years or so are the fact that at the local level, there's opportunities to do a much greater focus on preventing primary exposures. There's about 38 million older housing units in the United States that contain lead, and about 24 million of them have actual lead paint hazards as defined by the fact that the lead paint might be degrading in some way or disturbed in some way. So the impetus for this partnership was helping a number of localities work on developing legal strategies that look from the regulatory and enforcement perspective, as Amanda mentioned, all the way to how role litigation might play in trying to prevent lead exposures to begin with, or to remediate lead conditions where they are discovered and that they are impacting residents. So that's the impetus for this, is really to use localities as proving grounds and laboratories, and we hope that the communities that are participating in this effort, what you do can serve as models for other communities that are wrestling with these challenges. Thanks, Amanda.
And thank you, Arturo, and welcome everyone. My name is Greg Miao. I'm a senior attorney here at ChangeLab Solutions. I'm joined today by my colleagues, Cesar de la Vega, policy analyst, and Zach Hale, legal fellow here. And you'll hear a little bit more from Cesar and Zach shortly. I'm also thrilled to be joined by Jill Heaps, a legal consultant with Earthjustice. And I'm just going to turn it over to Jill here quickly to let her speak a little bit more.
Hi, for those of you who aren't familiar with Earthjustice, we work with organizations around the country to end the ongoing uses of lead and to reduce exposures from legacy sources. We work at the federal and state level, always with communities, to raise awareness and to tackle public health threats from lead. Thanks, Greg.
Thanks, Jill. And as a quick reminder about who we are at ChangeLab Solutions, we're an interdisciplinary team of lawyers, planners, and public health professionals and policy analysts working together to create healthier communities for all through equitable laws and policies. And if we can go to the next slide, thank you. Just a very brief disclaimer. The information provided in this webinar is for informational purposes only and does not constitute legal advice and we are not entering into any attorney-client relationships with any of you. So why are we here? Well, first, we want you to leave us today with a better understanding of the local legal strategies and policy levers available to you to prevent lead poisoning. Second, we want you to be able to spot some of the potential unintended consequences of utilizing these strategies and their implications for advancing your health equity work. And then finally, we want you to be able to access additional resources for each legal strategy and policy lever we discuss, and to be able to point to successful examples from around the country. To reach those objectives, here's a roadmap for our time together. We'll open with a brief explanation of why we're focusing on policy. We'll then spend some time exploring several legal strategies to reduce lead exposure. For each, we'll explore what it is, why we should consider using it, examples of the strategy in action, and some key takeaways. Those specific strategies are proactive rental inspection, rental property licensing, adopting a stricter definition of action level for lead, and renovation, repair, and painting. After that, we'll discuss some overarching considerations and highlight two additional strategies: strengthening tenant protections and mandatory testing. And finally, we'll close by leaving you with some key takeaways and resources to learn more about what we've covered today. So how does that sound? Well, hopefully that's good. Let's get started. All right. So why the emphasis on policy as a legal strategy to reduce lead exposure? Well, let's start by defining policy to get everyone on the same page. Policy is a tool used to change physical environments, community norms, and the way organizations and systems operate. Specifically, policy is a written statement that is binding and enforceable, and that is broadly applicable to a geographic area, type of institution, or physical space, and/or group of people. Policy has the potential to affect the decisions and behaviors of entire populations and can enshrine system or environmental change in writing to ensure that changes survive leadership or staff changes. And what can you do with policy? Well, one of the hallmarks of policy is that it applies widely across entire organizations, companies, or neighborhoods. So in short, you can reach more people with your work. Policy also helps you hold people accountable for the things they agree to do and helps to institutionalize good ideas. And you can also use policy to change, policy change to address inequitable impacts, whether unintended or intentional, of existing policies. And we'll come back to this ideas later. Finally, I'd like to note that policies can also be bundled to address complex issues and operate across sectors in a complementary fashion. For example, you'll hear later in this webinar about two complementary health and housing strategies that can be paired with lead exposure reduction strategies to promote health equity. And with that, I will pass it along to Jill.
So you may be thinking, hey, this is a legal strategies webinar. Why are we not talking about litigation? I know many of you from the pre-webinar survey indicated that you were interested in it, and I just want to give a brief overview of why we're not going to talk about it in depth today. You may have heard that California won a pretty sizable chunk of money to address lead poisoning issues from lead paint manufacturers. And they did this through bringing a lawsuit using the public nuisance theory to hold the manufacturers liable for the cost of addressing lead poisoning. The theory here is a public nuisance, which is an unreasonable interference with a right common to the general public. So what the municipality said is the public has the right to be free from lead poisoning. Manufacturers added lead to paint, and it caused this lead poisoning crisis. It costs a lot for municipalities to remediate it. The manufacturers knew the lead paint was dangerous, but marketed it for interior use anyway, and so therefore the manufacturers should be responsible for the costs to the municipalities for this crisis. So what exactly happened in California? Municipalities sued 3 paint manufacturers, Sherwin-Williams, ConAgra, and NL Industries, in 2000, seeking billions in damages for lead paint. 14 years later, in 2014, a trial court finally ordered the paint companies to pay $1.15 billion. The manufacturers appealed that, and in 2017, that amount was cut in half. But the companies also threatened to sue individual property owners who received help cleaning up their properties, claiming they failed to maintain their housing. And in 2019, 19 years after the litigation was initially filed, the companies agreed to a $305 million settlement. So why is this might not be a good solution for your area? Public nuisance varies from state to state, and several lawsuits in other states against paint manufacturers have already failed since 2000, particularly in Illinois, Missouri, and Rhode Island. These lawsuits are brought by governments on behalf of the public, so this is not a strategy for a nonprofit to undertake. And as you might have gathered, this takes a really long time. This process in California took 19 years and racked up millions of dollars in attorney's fees.
Great, thank you, Jill. So let's dive right in with our first strategy, which is proactive rental inspections. Next slide. So what is a proactive rental inspection program, or PRI for short? So although there is no uniform or standard PRI program, they typically share a basic program structure that includes registration, periodic inspections, and enforcement. Traditionally, code enforcement programs have been complaint-based, meaning they are in response to a resident complaint about a substandard housing condition. PRI programs are different. Under a PRI program, periodic inspections of rental units are conducted to ensure that units are safe and habitable and that property values are maintained. Frequency of inspections is often heavily dependent on the extent of a locality's resources. Localities will also have to decide on the types of rental housing to include in its program based on the locality's rental housing makeup and needs. Registration allows localities to know what rental properties exist, who owns them, and it helps them inventory their housing stock. Some localities require property owners to obtain a license before renting a housing unit in lieu of registration. And by moving away from the traditional complaint-based code enforcement programs, PRI programs can eliminate barriers that otherwise might not allow for all segments of the population to benefit from such programs equally. Next slide. So why else should you consider adopting a PRI program? Well, PRI programs help preserve safe and healthy rental housing. This is achieved by relieving tenants of the burden of having to force reticent landlords to make needed repairs and by providing landlords with notice of poor conditions, which then encourages preventative maintenance, a more cost-effective solution than deferred maintenance. PRI programs can also help protect the most vulnerable residents left behind by traditional complaint-based code enforcement programs. Many renters avoid notifying their property owners of the problems for fear of increased rent, retaliation, or eviction. This may be particularly daunting for undocumented renters. In a complaint-based system, these barriers result in the housing inhabited by the most vulnerable populations, which is often the least habitable, becoming more likely to slip through the cracks. A PRI program attempts to alleviate this. PRI programs can also help preserve neighborhood property values and a locality's property tax base by preventing the concentration of blighted properties. And finally, PRI programs provide localities with valuable information via the registration component, which helps localities inventory their housing stock and then tailor policy solutions to meet needs based on this information. So now I'd like for us to look at a PRI strategy in practice. And for that, we'll turn to Rochester, New York's PRI program. This program became effective in 2006 after a law was passed in the year prior. The program requires visual inspection for lead as part of its certificate of occupancy inspections of rental property. Certificate of occupancy inspections are required every 3 years for multiple dwellings, every 6 years for 1 and 2 unit buildings, and on request by a tenant, meaning that a complaint is filed. The program utilizes fines as an enforcement tool via the city's administrative code enforcement system. And as part of the program, an annual report is shared with the City Council on the number of inspections, passage rate, and program cost. And the County Health Department must annually report to the city the cumulative number of EBL, children, and properties identified with lead hazards by census block group. The program also makes the annual reports available online, as well as other key data, such as a searchable database of lead-safe units. The Rochester program is also supported by language prohibiting retaliatory action. Quote, "It is unlawful for an owner or any person acting on his or her behalf to take any retaliatory action toward a tenant who reports a suspected lead-based paint hazard to the owner or to the city." Retaliatory actions include, but are not limited to, any actions that materially alter the terms of the tenancy, including rent increases or non-renewals or interference with the occupant's use of the property. So in addition to Rochester, we flagged two other examples, one from Boston, Massachusetts, a large-sized city, and a small city in Toppenish, Washington. In the interest of time, I won't go through the details of those programs, but note that we've included hyperlinks to each of those programs for you to learn more about them. Next slide. So some key takeaways. Regardless of geography, the most effective PRI programs will, one, be tailored to the characteristics of the local rental housing stock. Two, they will factor in on the ground political and resource limitations. Three, they will anticipate potential challenges in adoption and implementation. And four, the most effective PRI programs will incorporate broad-based strategies to ensure that local rental housing remains not only safe and healthy, but stable and affordable for all tenants. So we'll learn more about some of these broad-based strategies, including those that strengthen tenant protections later in the session. And with that, I'll pass things over to my colleague, Zach.
Hi, so we will now be discussing rental property licensing. Rental property licensing is a broad concept that is used in a lot of different ways. Essentially, they're typically property-linked licenses. So each individual property that a landlord maintains would need to be licensed in this scheme. It can be a hook to, when coupled with other preventive policies, like the proactive rental inspections that Caesar was just speaking about and the others that we will hear about later. And it can provide a stronger enforcement and compliance mechanism for those policies. Because it is a broad type of category, that's good to go to this slide. It can be used in different ways depending on the resources available to communities, and I'll get to that a little bit later. So as I was saying, the rental property licensing system that any city could implement would provide a hook for prevention policies such as proactive rental inspection or registration. How this works is that if you require a license for each individual property, part of the license requirement can be that the property is inspected with some regularity, that it's put into a registry, that it is tested, that even the tests can meet certain specifications in terms of lead amounts, as we will again hear about later in the webinar. You can also kind of take the licensing program to the next level and implement performance-based licensing, which gives incentives and penalties based on landlord behavior and property status. So now we will look at a couple of examples of this as it is implemented in two quite different communities. One is Philadelphia has a basic level of rental property licensing that requires each property being rented in the city's jurisdiction to have a license. And as part of that licensing, there's a compliance element with the lead paint disclosure and certification law that the city has adopted. This is an example of using it for a hook for compliance with another law. The lead paint disclosure and certification law requires that all units built before 1978 and that will be rented to tenants who have children 6 years or under are inspected by a licensed lead inspector using the EPA or HUD lead standards. So the lead disclosure and certification law itself is an implementation of EPA and HUD lead standards applied to older units that are renting to families with young children. And the rental property licensing scheme allows the city to require that of all properties. And it includes a registry component as well, in that you're registering the properties that are of that age before the federal ban on lead paint in 1978. A different implementation of rental property licensing system is that used in Brooklyn Center, Minnesota. Much smaller, as you can see, the population there is 31,000, and their rental units, they have fewer than 1,000. So the types of rental, the scale of their rental registry system is not as large, and accordingly, performance-based licensing, which can take more resources, it's a little bit more involved, it may be more feasible for them. They have a really interesting system where they've created 4 tiers of properties that are based on how many code violations or nuisance complaints are received at each property. Your type 1 license, which has the lowest level of complaints, has an inspection every 3 years. So it's still being regularly inspected. They don't escape inspection, but they're actually allocating fewer of the limited resources to those properties who have not proved to be a problem. This goes up. Type 2 gets inspected every 2 years. Then in the types 3 and 4 licenses, they actually really ratchet up to an annual inspection for type 3, and you have to have a plan for how you'll fix your issues, and you have to start attending meetings for the Association of Responsible Management, kind of a landlord support group that is facilitated by the city itself. All the way up to the highest code of license, the type 4, you have a 6-month inspection schedule. You have to have monthly reporting on mitigation efforts on the issues that have been complained about, and you have regular attendance also of those meetings. So that can be a pretty burdensome, potentially resource intensive type of system to implement, and it's easier for communities that have fewer rental properties, but also does effectively prioritize resource management for those communities because they're not allocating resources to the lowest issue rental properties. Another potential consideration for a performance-based licensing system like Brooklyn Centers is that it's complaint-based, which creates some of the issues that Caesar highlighted before in terms of which tenants are potentially afraid to use the complaint system. So coupling a performance-based licensing system with something like proactive inspections or other ways of monitoring code violations would potentially mitigate some of those equity concerns. Okay, and then for the final slide in the rental property licensing, just want to highlight the key takeaways. It is an enforcement hook to help compliance with other regimes. We can also incentivize proactive behavior on part of the landlords. If they have reduced inspection and paperwork and renewal, that's going to be cheaper for them and easier to manage. So getting ahead of the game for them will be incentivized through performance-based licensing. But there are also, of course, resource considerations as with any policy, and communities should work to make sure that they're picking the type of rental property licensing system that's going to be most appropriate for them. And with that, I will hand things over to Jill.
Thanks. Hi, this is Jill from Earthjustice. And the third strategy is adopting a stricter definition of action level for lead. As we all know, there is no safe level of lead in the blood. So CDC, the Centers for Disease Control, adopted a reference level in 2012, which is by measuring the blood lead levels in children across the US and selecting the 97.5th percentile. And in 2012, they did this analysis and they defined the reference level as 5 micrograms per deciliter in order to identify children and environments associated with lead level exposure. But what they did in 2012 is they also committed to revisiting this level every 4 years. So in 2017, they had a work group on the revision of the blood lead level, and that group recommended the reference value actually be 3.5 micrograms per deciliter. So that may be coming down the pipe. Next slide, please. Why should we consider adopting a stricter action level for lead? Some of the benefits of lowering the blood lead level, while it may not seem like primary prevention, a couple of things that it's doing, it's stopping exposure for children, ideally at a lower level. So if we aren't preventing the lead exposure through these proactive rental inspections, we're hoping we can find the exposure sooner. So we stop those children from having higher levels of exposure, and also for younger siblings that come along, we are preventing their exposure as well. What does this look like? So in New York, the governor's budget this year took action by lowering the elevated blood lead level from 10 or 15 to 5 micrograms per deciliter. The New York State Department of Health is working on regulations right now to implement those changes. So that's an example of the change happening at a state level. In Pennsylvania, there's actually no state action level for lead, so that's happening. The changes there happen are set at a county level. In Allegheny County, the health department treats confirmed blood lead levels of 5 as elevated and takes action based on that. But in Philadelphia, they are only taking action at 10. So in 2017 alone, there were 1,800 children with blood lead levels between 5 and 10, and those children did not receive any services or interventions and are then likely still being exposed. So the action level for lead, what's the key takeaway? This might be done at a state level or at a local level, but how your state works depends on whether it can be done. Some state level action, states have home rule laws, and some states like Pennsylvania allow localities to make changes like that and to make rules like this. Other places may actually prohibit it. New York's laws would prohibit that and preempt any official action at the local level. So whether or not you need to do this at a state or a local level depends on your state. And then also, as you all may be thinking, lowering the action level for lead really only makes a difference if you actually have meaningful triggers, right? If you have meaningful interventions, meaningful remediation requirements, meaningful early intervention support for children who are identified through this action level. The next topic I'm going to cover is the renovation, repair, and painting rule. So what is the renovation, repair, or painting rule, often referred to the RRP rule? This is actually a US EPA rule that's implementing the Toxic Substances Control Act, or TSCA. And it requires firms that are performing renovation, repair, or painting projects that would disturb lead-based paint in homes, child care facilities, and preschools built before 1978 to be certified by EPA or an EPA authorized state, to use certified renovators who are trained in EPA approved training techniques and to follow lead safe work practices. One important note here is this is enforced by the EPA, the US federal EPA, unless your state has actually filed a petition called a delegation petition, where the state officially asks to control this program. Next slide. So as many of you know, renovations are a primary lead exposure method, and effectively implementing the RRP rules can protect children from exposure. One of the problems with how the RRP rule is currently structured and enforced is that where EPA is enforcing this rule, EPA just isn't set up to do local enforcement in this way. In 2016, the EPA brought a grand total of 3 enforcement actions of the RRP rule across the entire state of New York. In 2018, it had ramped up its enforcement and had 141 enforcement actions across 36 states. So that's 4 enforcement actions per state, and it's obviously just completely insufficient. So what can we do about this? There are a couple options at both the state and the local level. At the state level, it's possible to get your state to petition for delegation so that to take over the program. Another way that states have addressed this issue is to adopting a state level law that's parallel to the RRP requirements. So Pennsylvania's lead certification program is a state level law in Pennsylvania that mimics many of the RRP requirements, and so at least it gets the states have something now to enforce if EPA is not enforcing its own rules. At the local level, a couple from very basic RRP certification, some localities municipalities have a form that says, when somebody wants to do renovation, are you RRP certified? And there's just a checkbox without requiring proof. So one initial option is actually requiring proof that the renovators are actually certified. In places like Rochester, New York, they've incorporated the RRP requirements into a local ordinance. So kind of following Pennsylvania's model, but instead of at a state level, we're doing those into a local ordinance. And also you could support local nonprofits that provide renovation repair and painting training and awareness. So in Philadelphia, the Overbrook Environmental Center is a local environmental center that does the training for the local renovators. And so supporting a group like that not only helps build awareness, but helps support a local community center that's trying to both increase awareness and train renovators. Next, some key takeaways on the renovation, repair, and painting. This is a major pathway to exposing children to lead. And so getting at the renovation, repair, and painting and making sure they're done in a lead-safe way is critical to protecting children. We know that federal enforcement of this is minimal. Even when people complained about the low levels of enforcement in 2016, and EPA is really proud that they ramped up their enforcement, it's still just abysmal because EPA is just frequently not in these locations where the work is happening. So states and communities really need to find a way to implement these programs to protect children. On the long term, I would recommend trying to get your states to seek delegation so the state can formally be in charge of the program. In the short term, there are several ways to implement locally, either incorporating it into an ordinance, requiring proof of training, and supporting local groups that provide education. With that, I'm going to pass it back to Zach.
Hi, thanks, Jill. So this again is Zach with ChangeLab Solutions, and I'm going to now move into some overarching considerations that apply to all of these and other strategies that we may use to protect our communities from lead. So the first one that I want to talk about are generally strengthening tenant protections. So several of these approaches, they may rely on tenants to complain, in which case tenants may be afraid of retaliatory eviction or rent hikes. There also may be some concerns around where they're paying their rent. Are they going to stop paying their rent during the period of time when they are waiting for remediation, in which case does the landlord have a cause of action against them, and back and forth. So there are risks to tenants and uncertainties for tenancies that are created by some of these policies. So it becomes very important for communities to also consider strengthening either existing tenant protections or creating new tenant protections that are tailored to mitigate the risk. So why would you want to do this? Go to the next slide. We can see this can encourage and empower tenants to report violations. So in a complaint-based system, this is the only way that the authorities may know that there are issues, potentially dangerous housing issues. So knowing that you won't be retaliated against as a tenant is empowering. It can also avoid evictions and displacement, which has additional negative health effects on top of the already bad health effects of lead risk. There are also housing instability repercussions that you can avoid by strengthening tenant protections. And also it maintains the affordability and quality of housing stock. So by requiring things around, some places have rent protections or requirements or that affordable housing units aren't demolished and then replaced with new market rate housing that doesn't address the same population needs, you can put in some of these rent protections that help. We'll focus on two, then look at how they're applied in particular contexts. So two that I've referenced one of them just earlier and the need for those. One is to create a rent withholding mechanism. So this creates an escrow account where tenants can pay their rent into the escrow account so that they are showing that they're still paying their rent and abiding by the terms of their lease contract. But the landlord, who of course wants and needs that money, is not able to access it until they uphold their end of the deal and remediate any issues that the tenant may be having. These are implemented in different ways. One of the ways that I wanted to look at was Baltimore County in Maryland. When there are serious defects in a dwelling and the landlord hasn't corrected them within a reasonable time frame, Baltimore County has a law that allows the tenant to pay rent into
into a county court system, and the funds accumulate there and can be used to offset the needed repairs, so that the landlord, if the landlord fixes everything out of their own pocket, then they get the full rent amount. There may be some gray area in between where some of the fund is used to pay for it and the landlord then doesn't get the full amount. Or if the landlord fails to remediate appropriately or in a timely way, then the tenant gets the escrowed rent back. And there are other issues around relocation in that scenario, but just for where the rent goes, it's really useful for court systems that deal with tenant disputes to create an escrow account where tenants can pay their rent in the meantime while issues get resolved. Another way to facilitate these disputes that can arise out of complaints is to have a housing-specific dispute resolution system. This is, again, done in various ways in different communities, but essentially you're relying on either a mediation or alternative dispute resolution system or a court within the existing trial court level court system that is dedicated to housing issues. Any of these approaches represent progress for tenants who may otherwise feel overwhelmed to have just one place where they can go with their housing issues, that has court clerks who specialize in helping tenants navigate these issues, that have arbitrators or judges who are trained in these issues and become familiar with the processes involved, can really help move complaints and conflicts in the housing system along. Philadelphia has been implementing a lead-specific housing court that has been going on since 2002, and there's a good evidence base and some published public health research on the positive impacts of that. They not only deal with violations in a systematic and consistent way, which provides a lot of benefits, but also can facilitate with property management because they know the systems that exist and they've encountered these problems before. These expert court systems can help direct the landlords as well to help them because they also may need help navigating some lead mediation options. So the lead courts in Philadelphia, also Cleveland has a housing court, and there are hyperlinks to more information about those systems in the PowerPoint. So the key takeaways for strengthening tenant protections, again, it empowers tenants to actually benefit from the lead prevention policies that we have discussed in this webinar. They are able to complain without fear of eviction or to withhold their rent in a legal way that allows them to leverage their end of the contract. It also reduces the risk of negative spillovers from these policies that may be through eviction, displacement, or reduction of affordable housing stock would have a ripple effect that affects other tenants. And also it promotes health equity for a lot of those same reasons. It can empower tenants who otherwise would be the most hesitant potentially to complain. And with eviction protections and a housing court and rent withholding mechanisms, it may empower those same groups to come forward. So those are important strategies to implement. And I will pass it back over to Jill again to discuss mandatory testing.
Hi, this is Jill. I just wanted to also lift up a quick example from Buffalo on tenant protections, or an issue that I heard just last week from a community member, that when landlords were going to renovate or repair a place, there's problems with them kicking people out, not necessarily for an eviction, but just saying you got to get out of here while I do these repairs, and then tenants have nowhere to go. So in some places, emergency housing or temporary short-term housing during the renovation and repair of these lead-contaminated buildings can be an important protection as well. So now I want to talk about mandatory testing. Mandatory testing is mandatory testing of children at prescribed periods. Often that might be at 1 year and 2 year. Some places are doing it as early as 18 months. In some places, you would have to have testing before you enter into kindergarten. Right now, only 10 states and Washington, D.C. require testing of all children, and 8 states are mandate targeted testing based on whether the child has risk factors of where they're living. The remaining states only have recommendations or have no policy requirements. So why is this important? Next. So in order to provide lead-poisoned children the intervention and care that they need, we have to know how much lead they have in their bodies. And mandatory testing helps identify children exposed to lead. Without mandatory testing, and often with mandatory testing, you can see testing levels as low as 20% or 40%. And so we really have no idea of the scope of the problem if we don't have every child tested. Mandatory testing also helps gauge whether our primary prevention efforts are working. If you really want to know if your proactive rental inspection programs are working, what you really want to see is improved blood lead levels in the children in the area. And if you don't have a robust sample size, if the kids who are living in these homes that are being renovated, repaired, or proactively inspected haven't been tested anyway, and they're not on the radar, you won't have good information about whether or not your programs are working. So mandatory testing can be state mandated or locally mandated. New Jersey requires testing at 12 months and 24 months, or at least once before turning 6. Again, enforcement is still a challenge. In 2017, even with a state mandatory requirement, only 43% of children from 6 to 26 month age range were tested. Louisiana requires healthcare providers to test children ages 1 and 2. In 2016, only 21% of kids were tested. And in Allegheny County, which is Pittsburgh, in 2017, they required universal blood lead testing for all kids under 6. And they're required to have their first test between 9 and 12 months of age range. So trying to get at the exposures earlier than 12 months or 24 months. Next. So mandatory testing is important because it gives us information critical to understanding the scope of the problem, identifying the kids who need help, and also measuring the success of our programs. But even with mandatory testing, there remain issues with enforcement. So we've got kids that are falling through the cracks. I think this goes back to Greg.
Hi, this is Caesar here from ChangeLab. So I'll go ahead and take us home. So we've reached the home stretch, and I want us now to take a look at some key takeaways and resources. So at the top of the presentation, we laid out a few objectives. First, we sought to gather information that would allow us to identify multiple legal strategies and/or policy levers to act upon to prevent lead poisoning. We've discussed several this afternoon. In doing that, one takeaway that we hope became clear is the importance of taking a holistic approach to understanding a community's health concerns and the impacts of a specific policy strategy. Clearly defining your community's health goal at the outset can inform your policy strategy selection, and understanding your community's biggest concerns should help drive that policy solution forward. This was just brought up in the example that Jill mentioned of coupling 2 solutions, for example, PRI and mandatory testing. Second, we sought to gain a better understanding of how to issue spot potential unintended consequences and their implications for advancing health equity. We also talked about how different strategies can be paired to prevent and/or address those unintended consequences. So once that policy solution has been chosen, the work is not done. You must think critically about implementation and enforcement considerations, including making sure adequate resources are in place for effective enforcement, identifying the appropriate partnerships with community organizations, figuring out how collaboration across agencies will be operationalized, and being proactive in seeking out resident feedback as the policy strategy is rolled out in order to be made aware of potential unintended consequences that should be remedied. One potential unintended consequence that often comes up, particularly in the domain of proactive rental inspections, is a concern about protecting affordability. Earlier, you heard Zach talk about one strategy, which is coupling PRI with different tenant protections or strengthening existing tenant protections. However, there are other opportunities to help protect affordability, and for that, we can look to the Boston proactive rental inspection program that I glossed over earlier. So in Boston, their program, which requires rental property owners to be inspected once every 5 years, they collaborate with other city agencies and community-based organizations that provide housing repair assistance. So for example, the city's Department of Neighborhood Development has a lead abatement program that offers financial help via forgivable lead removal loans. And folks qualify for those loans based on income or having tenants who have kids under 6 and that are low or moderate income. And third, we sought to gather various resources for us to learn more about each legal strategy and policy lever, including successful examples from around the country. And we talked about the impressive work local jurisdictions are doing in several states today. We introduced everyone today to various policy strategies as lead poisoning prevention solutions. We not only highlighted tools, resources, and examples, but we also sought to raise awareness about, again, those secondary effects that could undermine health equity goals. In closing, we haven't advocated for a single policy or legal strategy as the silver bullet solution that will eradicate this challenge in your community. Rather, it is our hope that you can see how these various policy solutions are interconnected and in many instances complementary. Next slide. So we've also provided a series of resources for you all. Today, on this slide, you'll find various resources to learn more about the strategies we covered. They include both overview type resources as well as links to specific examples from local jurisdictions. Additionally, some slides that we've gone through already have their own hyperlinks that you can click through to learn more about specific strategies, as well as what's happening on the ground in different jurisdictions. Next slide. And with that, we've reached the end of our time together today. Thank you all for joining today's webinar. Many thanks to our partners today, including Earthjustice, the National Center for Healthy Housing, and the New York Community Trust. You will receive in a follow-up email a link to a post-webinar survey. We ask that you please fill that out as we hope to gather information that can help us shape future trainings, TA services, and resources that you may find most helpful. It was also mentioned that a PDF to the slide deck has been included in this presentation, so you can access that as well, either right now or afterwards via the follow-up email. And with that, we thank you for your time today and wish you a great rest of your afternoon.